Okay, hello everyone. Thank you and welcome to our special event. Tonight we're looking at the High Court decision to allow 50 asylum seekers and refugees to take legal action in the Australian courts. Thank you for coming and welcome. I'm Tim Ginty from the National Justice Project. I'm joined today by Paul Gregoire. He's writing with the Sydney Criminal Lawyers. Thanks, Paul, for coming today. Anna Talbot, Senior Solicitor. She's been leading the fight against the government, trying to seek justice and accountability for our clients for many years. And George Newhouse, the Director and Principal Solicitor here at the National Justice Project. So thank you all for coming tonight, and thank you guys at home for tuning in. But before we do begin, I would like to acknowledge the traditional custodians of the lands that we're living in and working on today. That's the Gadigal people of the Eora Nations here in Sydney City, but I also know that we're being joined by people across Australia. So I would encourage you to let us know what lands you're joining us from in the comments below, in the chat box. You can put that there, we'd love to know. And we'd also particularly like to extend our respect to the First Nations clients of ours who entrust their stories to us. It's their determination and strength that keeps us going. So thank you, everyone, and I encourage you to put in your the lands you're joining us from in the comments below. And I would also want to thank everyone who's made a donation to the campaign so far. That's over 800 people have already made a donation. We've raised, I think, nearly 80,000 at this moment. We've got a big target. We want to get to $150,000. So please, if you can contribute in any way, you can make an impact right away by allowing our clients to keep on the fight against the government for justice and accountability. If you have made a donation, thank you so much. Maybe you can put in a comment below about why you chose to make a donation. And maybe you can tag some friends who you think might be interested in also making a donation. Because we really need your support. We rely on your support. We don't take any government funds. So please get behind the campaign. And without further ado, I'll pass it on to Paul.
Thanks,
you can
Tim.
take it from here.
And thanks to everyone who's watching at home. I'm putting the questions to the panellists today, George Newhouse and Anna Talbot. George Newhouse is the Principal Solicitor and Director of the National Justice Project. George has spent years trying to reshape Australia's legal system in favour of some of the most marginalised people through strategic litigation. His work has had a ripple effect for countless asylum seekers and refugees, as well as First Nations people who've been experiencing discrimination, prejudice and racism. So thanks for joining us, George.
Thank you, Paul.
And Anna Talbot has worked hard as a frontline advocate for the rights of refugees for many years. She's run many cases in the federal court to force the minister to provide essential health care to refugees, some of whom have been close to death. Anna has also provided guidance to other lawyers in relation to cases involving refugees on Nauru. So thank you, Anna, for joining us.
Thanks, Paul.
And so firstly, I'll be putting some questions to Anna. Anna, I understand that you have to protect your clients' anonymity, but broadly speaking, can you tell us about some of the refugee and asylum seeking clients you've represented in the past, and what kind of situations have they fled?
Absolutely. Before I do, I'd also just like to acknowledge that we're on Aboriginal land that was never ceded, and pay my respects to elders past, present and emerging. And getting back to your question, I have been working with refugees for a number of years, and yes, I can't talk about any of their stories individually, but I can give you a bit of a picture about the backgrounds that they come from. And the lesson that I've learned over this time is they're people just like us. They're living their lives, going to work, studying, playing with their friends after school, doing the school run in the morning, whatever it might be. For some reason, they have not been able to continue to do that anymore. They might have been active in politics, maybe teaching their historical language to people in their local community, in a country where that is not only illegal but something that you're liable to be tortured for or imprisoned for, or put to death. They might be in a domestic violence relationship. We all know the challenges that come with leaving a domestic violence relationship, but these people are living in countries where it's illegal to leave your partner, your husband, and doing so again puts you at risk of death. So for whatever reason it might be, they have had to leave their country that they know, love, live in, their friends, family. They've had to leave it urgently. Usually they don't know where they're going. Usually they just end up crossing a border, taking a plane. They don't know if they're going to Australia, the US, Europe, no idea. They just know they can't stay where they are. And so they get themselves into a position where they need to ask Australia for help. For my clients, those that I've been acting for most recently, instead of helping them, we sent them to Nauru, put them in indefinite detention, and watched as their mental health deteriorated to the point that they felt completely helpless and unable to live.
Okay, and so today we're here to discuss a High Court decision that was made on the 2nd of December, which involved the High Court deciding that the Federal Court can hear breach of duty of care cases brought against the Minister, that the Federal Court can hear those cases, not just the High Court. So you were representing, Anna, children who'd been detained long term on Nauru in the latest case. What sort of circumstances were these children facing, and what state were they left in?
So as I've explained their backgrounds, a lot of the children obviously weren't the decision makers of having to leave their countries. They were fleeing with their families. Most of them didn't know they were leaving. Sometimes they were told they were going on holiday. They end up in Nauru. When they get there, most of them were doing okay for a while. 6 months, a year. They were living in terrible circumstances. They were in tents without access to enough water, without access to enough food. There was rodents in the tents. There was no privacy. There were security guards coming in, looking at them at all times of the day and night. They were having a pretty tough time, but they were doing okay. 2 years in, things start getting a bit tough. They move out into the community, which is better because they have freedom, but they also have less protection. They find themselves in a country where the police are not really that inclined to help them if they're getting subjected to violence, or their things are stolen, for example. The children are getting bullied at school a lot of the time. A lot of the children were unfortunately sexually assaulted, sometimes quite badly, sometimes less badly, but the overwhelming situation is one of a lack of safety. This continues on. 3 years in, we start seeing children developing really terrifying symptoms, very young children, younger than teenagers too often. 4 years in, we start seeing this really terrifying situation of children either developing what later became known as resignation syndrome, starting to talk about suicide, starting to... and before I go any further, I'd just like to say that this is traumatic, so if you're upset by this, you might want to mute or something. They were starting to talk about suicide, they were starting to hurt themselves. And then 5 years in, we started to see suicide attempts, which was just terrifying. I mean, these are children that shouldn't even know that suicide exists. But after being in this environment for 5 years, having seen other people sew their lips together, having seen other people, adults, try and kill themselves, having seen a young man who they all respected set himself on fire and die as a result of that, these children weren't offered the appropriate care outside of all of those traumatic events, and then after experiencing those traumatic events, they weren't given trauma counselling by and large. They were just told that they should keep going to school. So it got to the point with our clients. George ran the first case of a child at the beginning of 2018, you'd run earlier
Christmas
cases.
17.
Yeah. And that case was a case that was reported, which was FRX 17. She had attempted suicide. She was younger than a teenager.
Damn.
It's a really tragic situation. Then after I came on board, we found out about this resignation syndrome, which is a situation where children, teenagers, sometimes young adults, but often, you know, I was seeing people 12, 14, 16, 18 taking to their bed, not eating, not talking to their loved ones, not leaving their bedrooms for days, weeks. It got to months, and nothing was really done to help them. They were needing assistance to toilet themselves. They were not showering. They were at risk of a syndrome called refeeding syndrome, which means that you've lost so much, you haven't eaten for so long that starting to eat again is dangerous. These are children that this is happening to. So we had to go to court. We had to go and force the minister to do something. We had provided the minister with the medical evidence how sick these children were. The minister knew what was happening to these children. It was only when we went to court that the minister took action.
So that's a really rare syndrome, and they've all developed it at once.
A lot of children developed it. It had been seen, we were told by the psychiatrists that were helping us, it had been seen in refugee communities in Scandinavia previously, but
It is rare.
it's very, very rare, and it's in this circumstance of a complete lack of safety.
So given all those circumstances, how did you feel about the High Court ruling in favour of your clients?
Oh look, I had some mixed feelings, I have to be honest. I became very nervous because I know how much work we've got ahead of us. I'm really excited to be able to push these cases forward. I really feel it's incredibly important that the government is held accountable for what it has done to these children. It knew what it was going to do to these children. It had the research to show that keeping children in these circumstances was damaging. It saw that it was damaging the children. We were showing the government the evidence that it was causing harm. So I'm really excited about the ability to hold the government accountable for that. I'm excited about getting justice for our clients so that they can pay for the medical care that they wouldn't otherwise need. A lot of them are in quite dire financial circumstances. They can't afford the medication that they need. They can't afford the health care that they need, the mental health care that they need. So it's really, really important to us to be able to support them to access that care, but we've got so much work to do. We've got so many experts to brief. We desperately need support to be able to get those expert reports in. We've got so much evidence to review. We've got a lot to do, so it's nerve-wracking, but I am pleased that we can continue to move forward.
And you've got quite a few cases personally.
I do, yeah. I ran a number of cases, so they're still in the federal court, and we have additional cases that we'll be filing shortly.
Okay, and so on to you, George.
Yes.
So can you describe the steps that took place before the decision was made on the 2nd of December?
Yep.
Why did these cases end up before the High Court?
Look, as Anna was saying, and Anna's done a fantastic job managing these cases to date, and there's dozens of them that are in the pipeline, and I can understand her trepidation. But we started acting for a number of very, very sick children. As you've heard, they had resignation syndrome. Their lives were at risk unless they were moved to Australia. We ran around a dozen cases together with other law firms. The trickle of cases became a flood. People on Nauru whose health was rapidly declining were just falling into a hole because they were seeing some of their friends and family members successfully moving to the United States, and for those who remained, a pall of hopelessness developed, and that hopelessness exacerbated their psychiatric conditions. So the trickle became a flood. We started more and more proceedings in court. The federal government started to look for some way of putting a brake on the proceedings, and they came up with this obscure technical argument that Section 494AB of the Migration Act meant that we couldn't bring any of these cases. It was a real attempt to slap us and stop us from bringing these cases in the federal court. Now, the first judge that heard one of these arguments about Section 494AB said, look, it's a matter that I can consider later on at full hearing, and said, I'm not going to entertain this argument. And in fact, I think the High Court's basically said that judge was right.
Right.
You could hear it, and if there's an issue, we can deal with it at full hearing. But what happened was the federal court got worried because in every single case, and by this stage there were dozens in the federal court, the Australian government solicitor on behalf of the minister and the government was raising this technical point. So they were being bombarded with this complaint, with this allegation by the government that the federal court couldn't hear the cases. So ultimately the court decided to pick 4 cases, 2 of ours from Sydney and 2 of Maurice Blackburn's from Melbourne. And they said, we're going to run these as test cases and work to determine this preliminary issue about whether the court has jurisdiction. It was a rather nuanced decision of the full federal court that found that our clients could proceed. There was jurisdiction in the federal court, and for some reason, well, not for some reason, they felt that because the Melbourne cases were stopping the minister from sending the children back, that meant that they had triggered Section 494AB, whereas our cases had not. I hope I'm not being too technical, but that was the argument. The High Court basically said that's not right. That analysis of the full federal court is not right. That's why they allowed the appeal. There was a bit of confusion at the time. Why did the High Court allow the appeal? Well, they had to unscramble the egg that the federal court had created when they found that our cases had every right to proceed, but the Melbourne cases didn't.
Okay.
The High Court said, no, we're going to start again. And essentially they said all the cases can be heard in lower courts. What this clause means is the government has a defence. If they want to raise it, they can raise it. Cases get to be heard in whichever court the cases proceed in. Some will proceed in state or territory Supreme Courts. Some will proceed in district courts. Some will proceed in the federal court. All those courts have jurisdiction. The government can raise a legal defence under Section 494AB, but if they do, they will not be behaving as they should as model litigants, because all people have to do to get around that defence is to start in the High Court, and the High Court will just send it back down. So the full bench of the High Court, it wasn't the full bench, I think it was a 5-judge decision, said this is just nonsense, just get on with the cases, essentially.
Mm-hmm. And in your opinion, did the government pull that section out of their back pocket, or did they have to scratch around in the legislation to find it?
Well, my view is, and this is no personal criticism, they were digging around for some kind of hook to stop, to put a brake on the cases that we were running, and to some extent they did. There are, I reckon about 50 cases in the pipeline that have been put on hold pending this decision. Mm. So they were successful in putting a screeching halt on all these cases. But it's a really technical point. Someone was up all night combing the act, trying to find some way of stopping us. And it's a totally pointless piece of litigation. Just there, I think it's legal bastardry, frankly, to just stop us and all the others who are running these cases from proceeding to justice.
So it was a dodgy piece of law to stop this?
Well, I think this case raises, you're asking some very good questions. This case raises a tension between the courts and the government. Governments don't like courts or judges overseeing their actions. They don't like being held accountable. So the government tried to push this Section 494AB of the Migration Act to stop courts from checking them, from saying you're not behaving in accordance with the law. Mm-hmm. And what the High Court has done is actually really limited the operation of that clause. So here you're seeing we don't have many constitutional crises in Australia, but this case for lawyers is quite interesting because it shows that line where the court is saying, no, you can't get rid of us, we're still here, and we've got jurisdiction to oversee your bad behaviour.
And I've got one more.
Yeah, please do.
I mean, is this a sort of law or legislation or section that a Bill of Rights would, people are calling for a Bill of Rights, would that rule?
I think so.
Yeah.
I think so. This is called a privative clause, and the government has really started using it and developed it as part of its policy direction, because under migration laws, because they really don't want courts exposing the horrors of what's going on in the system or holding them accountable for it. So I think the answer to your question is yes. That's what that's what this law is designed to do. Did I get your point?
Yeah. Okay. And so I understand that there are about 50 other cases in the pipeline, breach of duty of care.
Yep.
What will this mean for the refugees and the asylum seekers, but what will it also mean for the government?
Well, I think, okay, they're kind of mirror images. First of all, for our clients and for the clients of Maurice Blackburn and others who around Australia, it means that they'll get justice and they'll expose the government to, their misconduct to sunlight, and they might even get compensation in the end, but they'll certainly get some accountability. And that's what the government's afraid of, and that's why they fought this case. For the government, well, I think they'd better have a good long look at themselves, because I think it's a setback for these privative clauses where they try and carve out the court's ability to observe and examine their misconduct. So I think they've had a real setback, and I think ultimately hopefully this will lead to change, because they can't keep getting away with bad conduct if it's going to be exposed through the court. So I think that's the mirror image of this litigation.
Okay. So thank you, George, and thanks, Anna, for those questions. We've had some questions that came in earlier from some of the people who are watching. So I'll put the first one to you, George.
Yep.
In the ABC reporting on the day of the decision, it seemed to suggest that you lost the case.
Yes.
The case was lost. But your reports, other reports in The Guardian, you won.
And Sydney criminal lawyers got it right too.
That's true.
I can tell you that. But look, I suppose it was confusing, and this is the problem these days. The media has to report quickly. Court reporters probably just look at it and says appeal upheld. Now, as I mentioned earlier, what that means is that the High Court needed to rewrite what the full federal court had said. They essentially they found that the full federal court decision was wrong, because the full federal court said there was no jurisdiction in the Melbourne cases to hear these complaints. They said ours were okay. We were very careful not asking for orders that stopped the minister to send the kids back to Nauru. And so the federal court had said, oh, you're okay, but the Melbourne ones aren't. High Court basically said, no, we're going to uphold the appeal because we're going to overrule the full federal court and start again. But when the journos looked at that, they said, oh, we lost and the minister won because the appeal was upheld.
All right.
But when they upheld it, they actually cut back the meaning and operation of Section 494AB. So it was a loss for the government. But it takes a bit of reading to understand what the High Court said. So I think initial reports got it wrong. They were acting quickly. The appeal was upheld. They thought the minister won. The reality is that wasn't the case.
Okay. And then I've got a question for you, Anna. And it's from a viewer called Inga. Are there grounds to take the Australian government to the International Criminal Court, The Hague? In so doing, this will are there grounds now? Yeah.
Look, that's a question that people have been looking at for a long time. And it actually has been taken to the International Criminal Court. I think it was in 2014.
Yes.
Andrew Wilkie sent a complaint to the International Criminal Court seeking an investigation on the basis that what Australia was doing in Nauru and in Papua New Guinea was in contravention of international law, alleging crimes against humanity, torture and cruel, inhuman and degrading treatment. Very serious allegations. And the International Criminal Court made a decision on that request for an investigation earlier this year, I think it was, saying that cruel, inhuman and degrading treatment had likely occurred in offshore detention, but it didn't meet the threshold of an International Criminal Court investigation. And that's essentially not saying that what was going on in Nauru and PNG was okay, but more a reflection on the nature of some other conflicts in the world. So what that basically leaves us with is the Australian domestic courts.
Okay.
We don't have recourse to a higher court somewhere else in the world. All we've got is our own courts. What our High Court has said is that we're not going to be treated as a post box.
Yep.
We're not going to put up with the Commonwealth's legal backflips, trying to delay and obscure the rights of people who are being affected by the Australian government's actions. The Australian courts can hear the cases and make decisions based on the evidence that they receive.
Yep.
Okay. Nice.
Well, thank you, everyone. Did you have any more questions there, Paul?
No.
Well, I just want to say thank you to everyone who's listening at home. We've had a whole bunch of comments come in, a lot of support from you guys. Thank you for all your comments. Marion, Carol, Dawn, Jackie, Business. We've got Chris, Steve's listening in. Thank you guys so much for your comments, for your support. I'll remind you guys that there is a campaign where we've launched to try and keep these cases going for the next 12 months. We've got a lot of legal work ahead of us. Anna, you would know that. So we're going against a government that has very deep pockets, so we need the support of the community. And we've already had 800 people so far donate. We've raised nearly 80 grand tonight. So thank you guys for that. Thank you for your contributions. And please share the campaign. Share this video to people who you think might be interested, so we can get that word out there and we can help broaden the fight for accountability and justice. So thank you so much, Paul, for coming.
Thanks, Paul.
Thanks for having me. And
Thanks,
thank you, bye.
Anna, George. Thank you so much, and thank you guys at home.
Thanks
Thank
all.
you.
And goodbye. Bye-bye.
Thank you, Paul.